Hello, everybody. It's Rick. It is the 24th day of November 2018. If you need to reach me, my email is rick, RICK0327 at me.com. Okay, you're reaching out to me because you're interested in receiving my paperwork for child support. Okay. All right, so we're going to be talking about, a pretty quick video about how to attack a contempt order. Okay, so somebody reached out to me and they sent me a copy, all right, of, here it is, and these are good. Family Law Contempts Bench Book. These are for judges. Okay, now this is in California. Okay, so there's a lot of California law here. I'm going to leave this in the description box, or I'm going to leave a link for this. Okay, but again, the case laws will apply in your state. Okay, because they cite some Constitution, United States Supreme Court case laws which apply. Okay, and here's the thing, right here. Here's the word we're looking at right there. Informed consent. They don't do that with us. Okay. See, these cases could be easily dismissed, and they know it because it's really not difficult because we figured out what's going on. We haven't consented to contract with these people. All right. This is a customer service based business. Okay. And what they did was they configured it to look like a court case, and then they make it out, I've mentioned it hundreds of times already, how it's all set up to look like a courtroom scenario, and they're ordering you to pay support when they need your consent. Okay, because it's a contractual thing. They're calling you an obligor. You cannot be ordered to be an obligor. Okay, they cannot order you to they cannot order you to be a customer. That's really what they're doing. They're ordering you to be a customer. And then what happens is the custodial parent, which is 9 out of 10 cases or more, 9.5, whatever, is a mother. And what they did was the mother, and I'm repeating this because I always have new subscribers, so if you've heard this before, it's okay also because it's repetition. Okay, but the mother applies for welfare and they try and blame it on you. So they're going to try and say you're the reason why she's applying for welfare. But meanwhile, when they get you to pay child support, she still receives welfare. So it's double dipping. But so she gets the welfare from the state and the support from the state. So and the state gets from you, they get federal money from because you're paying. They're taking the money from you, and then they get 66 cents on the dollar from the feds. Okay, and so what they did was they have these handbooks for the judges. So you're supposed to have informed consent. All right, so let's look up informed consent. Okay, right here. Procedural requirements, informed consent. This is a case law. Reaffirms another principle of law, which is universally applied to criminal cases, but has often been ignored in quasi-criminal contempt cases. And this is also for civil cases as well, all right? Quasi-criminal, okay? Informed consent and awareness of rights. Now, I've mentioned this in my videos many a time, that I don't understand why, there's not like a Miranda warning for us. So like when you get arrested, you hear the whole spiel. You have the right to remain silent, da da da, all that stuff. Well, they're supposed to do that with us as well. That's what they're talking about right here. Okay, and when I know this because I hear it all the time from people that reach out to me. The courts are not kind to you. They're very abrasive. They don't want to tell you. They tell you, get a lawyer. I'm not allowed to give you legal advice, which is bullshit. Okay? If the court is providing you equal protection of law, they're supposed to help you. You understand? But it's convenient for them to say, we're not allowed to give you legal advice. Get a lawyer. Why? Because a lawyer works for them. You get a lawyer. The lawyer is going to, maneuver you, massage you into doing what they want you to do. You understand? So they're supposed to provide you informed consent. All right. Now here's the key right here. Number 3, written waivers of all constitutionally protected rights, or alternatively, a clear waiver on the record. So now what that means is if you're held in contempt, all you got to say is, where is the copy of my signed waiver? Okay, when did I waive my rights? I don't recall waiving my rights. So, because you're supposed to have so that's what the informed consent is all about. They're supposed to inform you of your rights. Informed consent, consenting to the proceedings. Okay, it's hilarious. All right, so I put some slides quickly together here. All right, I put here California because again, that's a California handbook, but again, it's the same in every state except what it is. They're using their codes and stuff, so I don't want you guys to use the codes unless you live in California, of course. All right, so all right, so that's right here. I talked about this. All right, informed consent is an agreement to do something or to allow something to happen. Right? See the word there? An agreement. It's a contract. All right, it's a contract. So it's like they need your consent to participate in this whole thing. All right? So you cannot be in contempt if you did not provide consent. So all you got to say is, where's my waiver of rights? It's really that simple. All right? Something that happened made with complete knowledge of all relevant facts, such as the risks involved or any available alternatives. Okay, the risks involved, if you proceed without a lawyer and all that stuff. All right, what you can do. They don't do that, by the way. Does anybody recall being provided available alternatives? You know what an available alternative is? Do you ever think maybe you could sit down with the baby's mother and work out a deal? Say, I'm going to give you so much money and I'm going to pay you directly. They don't want to do that. All right. So you guys can read this over. It's real simple stuff. Again, the court must prove informed consent was offered and written waiver of rights was provided. Okay, real simple. Okay. Family support orders are enforceable in the same manner and to the same extent as a child support order. All right, I just copied that. Language permits use of the concepts of Moss and Ivy for contempt enforcement of family. Thus, the ability to pay is no longer an element of the prima facie case in a case with a recent order and inability. So what they're saying is that if you were provided an order, all right, and you're aware of it, you had the opportunity to object to say you couldn't pay. You just can't use it as a defense after you stop paying. You understand? But if a support order is issued and you weren't given the opportunity to say, I don't have the ability to pay, then that's a different story. But basically, what they're saying there is that you were there when the support order was issued. You can't say now that you don't have the ability to pay. All right, non-support and I love the attorney fee stuff. Cracks me up. like you have to pay the attorney fees when the attorney's already being paid. All right. It it's used to be said that in order to establish a prima facie case of contempt, it is necessary to establish the following facts. A lawful order of the court was made. Okay. A surrogate judge is not a judge. So we already know, we've gone over this, that it's not a lawful order. All right. It's an administrative order. Really, that's what it is. So it doesn't have the same force and effect as a judicial order. The citee had knowledge of the order. The citee had ability to comply with the order. The citee was here's the key word all the time, guys: willfully. They have to prove that you willfully disobeyed a support order. Okay, they have to prove it. And you know how they can do that? By providing you with a copy of the waiver of rights. Because if you waived your rights, you have the ability to pay. I mean, that means you do know your rights. All right, knowledge of the order. Okay, so in other words, you must have knowledge of the order. Now, if you're one of these guys out there who, they claim they notified you, right, and you just didn't show up to court, that's a default. Usually defaults and contempt kind of go hand in hand. All right. So, again, it's all about willfulness. Did you willfully violate any support order, willfully violate a law? Well, how can you willfully violate something if you didn't know about it? Okay. And again, them notifying you by mail does not fly. They want you to think it does. I've had a couple of people reach out to me, and what they'll use as what they'll claim as proof that you were notified was a woman, Jane Doe woman. They handed it to a Jane Doe woman, or John Doe male. Well, that's not the same. That would not fly in a lawsuit case. Okay, you got to be properly served. It's the same thing. Okay, especially when they're going to be depriving you. See, now they hold that high standard when it comes to somebody being jailed. Okay, that's a deprivation of your liberty. Okay, so when you're restrained physically, that's a restraint of your liberty. All right, so we got life, liberty, and property. Okay, so we already know that they have to properly notify you by process server, where a man or a woman walks up to you and hands you a notification, a notice to appear, a summons. Okay? Now, why is it different when they're taking, remember, there's life, liberty, property. Why is it okay for property for them to mail it in the mail? And some Jane Doe or John, all the person has to say is they saw a woman walking into the address, and they know a woman lives there. They don't even know the woman lives with you. What if it's a multi-family residence? Okay, it's just a slick way of trying to claim that you were lawfully served. So your argument's going to be, I must be served personally. In order for them to have personal jurisdiction over you, you have to be properly served. Okay? So these are going to be your defenses, all right? All right, guys that have my paperwork, this is what I have noticed: the court, the vacate order of contempt. All right, this looks a little different. You guys have it. Those of you that got my paperwork recently, you have this. Okay? I just changed the wording on this today. All right. Very simple, very quick. All right. And really what it comes down to is, where is the written waiver of my rights, which is proof that I was provided informed consent, that I complied with the informed consent. I consented. All right. All right. real quickly, yeah, save. Hold on here. All right, this will be in the description. This is good. Listen, this will help you guys. Okay, this is what the judges are doing. You know what they're looking for. All right, I think this is it here. Nope. All right. You know, I don't run to my computer like I used to back in the day when I first started getting people. Little victories. I used to run to the computer and make a video right away 'cause I was happy. I'm proud to help people. Uh, I've helped a lot of people now, and it's like you become callous to it. I've had a lot of people notify me that their driver's license has been either restored or prevented from being suspended. And I just got this email yesterday from Bob here, and so I just want to show you guys that when what happens is people receive in the mail that their license is going to be suspended. So what I have, because I provide driver's license suspension. I mean, think about what I provide you guys. Affidavits to file before going to court, affidavits for child support situation, affidavits to sue judges, affidavits, you know, that for your employer, dismissal affidavits and vacate. Um, you know, right? We just talked about today, contempt, default judgments. Okay, clerk paperwork, because the clerks are real rotten people. I mean, they're really disgusting people. Um, Objections, right? Objections. I mean, these are all different scenarios I'm providing for really nothing. Really nothing. I can get a lot more money. All right, but again, I like to help people. Writ of habeas corpus paperwork. So anyway, he just wanted to let you guys know. I want to let you guys know that let your viewers know that I look on the Department of Safety website and they showed it had suspended his handgun permit, but not his driver's license. When I called and asked why they didn't suspend the driver's license, she said because he sent an affidavit weeks ago. It was the cease and desist, basically, and it worked. So, it's proof. He's not I've heard a lot. I've had several people reach out to me that I've helped them get their license restored or prevented from being suspended. So I mean, right there, that is worth its weight right there for these paperwork that I provide. It's proof that my paperwork works. That's what it is. It's not garbage. You guys are not receiving garbage. And here's the thing: if the paperwork doesn't work, it's not because of anything that I'm doing. Okay, it's not because of me. It's because of the people that we're dealing with. We're dealing with judicial bullies. Actually, I have to write an objection for a guy who submitted a writ of habeas corpus, and uh, the judge that dismissed it was a real wise ass. Okay, and he was claiming that the information provided was uh, what was it? Unavailing. He was unavailed. Like he wasn't, it didn't he we didn't, reach the level of proving a point. And he was being a smartass, okay? And he used the old nobody was jailed horse shit, okay? Writ of habeas corpus is for all types of restraints and oppression, okay? A lot of people do not know about this. Lawyers will not use this because it's a quick remedy. All right, they're not allowed to use it, lawyers. Okay, and they're not allowed because they're not allowed to come into court. What if people are sitting in the in the what do you call it, in the seats in the courtroom, in the observer section, and they, oh my God, all I gotta do is file a writ of habeas corpus. Is that it? They don't want that to get out there. You understand? So it's out there that, there's people like myself that have writ of habeas corpus paperwork that kind of, it's sometimes it's a little lengthy because I have to box them in. So, this smart ass, was being a wise ass, with his response, this judge. So, I'm gonna provide him with some. I am gonna avail upon him that he should have, complied with the judicial notice by the Supreme Court that says writ habeas corpus can be used for non-physical restraints, and it can be used against lawless state courts who are violating your rights, your inalienable rights. Okay, that's it's not maybe not they don't use the inalienable rights, but they're violating your rights secured by the Constitution, and that is I forget Nelson, whatever. It's in my paperwork. Those of you guys that have it, it's in my paperwork. All right, so listen, 21 minutes, and so again, if you guys want to reach out, you got a contempt order, you want to get stopped, reach out to me at rick 0327 at me.com. I'll talk to you guys later.